The central issue in the Deepwater Horizon case involved whether the scope and amount of additional insured coverage should be interpreted solely by reference to the terms of the insurance policy, or whether the scope and amount of additional insured coverage had to be interpreted by reference to the underlying contract, and in this case it was a drilling contract between Transocean and BP, involved in the Deepwater Horizon Gulf oil spill in 2010, whether and to what extent the insurance policy had to be interpreted and applied by reference to the underlying contract. So the key issue in Deepwater Horizon was that the drilling contract provided for Transocean to give certain indemnities to BP, really solely with respect to above the surface of the water issues. And the contract also required Transocean to extend additional insured coverage to BP with respect to those indemnities. The insurance policies themselves, however, that Transocean had purchased, provided what appeared to be rather broad additional insured coverage, extending additional insured coverage for, BP argued, the full amount of the insurance policies for any type of liability above or below the surface. And the court in the trial court, in the MDL court in Louisiana, initially sided with the insurers, who said, no, you really have to limit the scope of the additional insured coverage to what was provided in the drilling contract. The Fifth Circuit initially ruled in favor of BP and held, relying on this Atafina decision from the Texas Supreme Court, that in looking at the additional insured coverage, if the insurance policy itself did not clearly, specifically, and unambiguously refer to and incorporate by reference limitations on the scope and amount of additional insured coverage that were contained in the drilling contract, then the insurance policy was wide open and could apply to any sorts of liabilities of BP above the surface of the water, below the surface of the water, for the full amount of the insurance coverage. And this was a critical issue because the above the surface water liability for BP was basically minimal. And Transocean was indemnifying BP for above the surface of the water issues. The below the surface of the water issue, where the oil was discharged from the Macondo well, that's where the significant liabilities lay. And BP was trying to get access to about $750 million of Transocean's insurance coverage through this argument. So the Supreme Court was given the case by the Fifth Circuit in what was really a very surprising turn of events. After the Fifth Circuit had initially ruled in BP's favor and found very broad additional insured coverage, not limited by the terms of the drilling contract, the Fifth Circuit reversed course, withdrew its opinion, and certified the matter to the Texas Supreme Court. The Fifth Circuit basically decided, we're not going to figure this out, let's let the Texas Supreme Court decide it. And the Supreme Court eventually did issue the ruling that, again, turned the tables again, ruled in favor of the insurers, held that the language in the insurance policies made sufficient reference to the drilling contract, to the underlying contract, to allow the insurance policies to sweep in the limitations on scope and amount that were set forth in the drilling contract. So end result, not good for BP, but definitely provided more certainty and clarity, I think, around the additional insured coverage issue, in Texas at least. I think it's been very interesting because I think that the general reaction in the industry was fairly positive towards the Texas Supreme Court's decision. My sense is that most of the insureds operating in the industry, as well as the insurers, had a general sense that the court got it right, and the parties generally really do want their insurance to be aligned with the provisions in their service contracts. And I think there was a lot of trepidation, a lot of anxiety in the insurance community on both the insurer and the policyholder side when the Fifth Circuit had ruled as it did initially. A lot of concern about, do we have the proper language in our insurance policies that links those policies to our service contracts? Do our service contracts have the proper language that limits the additional insured coverage? So I think largely the reaction in the industry has been one of accepting somewhat relief about the Texas Supreme Court decision. The one thing I would say is that there's a little bit of concern that I have that there may almost be a certain amount of complacency, that having seen the Texas Supreme Court rule in a fairly broad fashion that the insurance policies could, through fairly vague reference to other contracts, cross-reference those, incorporate those by reference. Before the Supreme Court issued its decision, in the wake of the Fifth Circuit going the other direction, the parties were a lot more concerned about really tightening up the language in their policies to make sure that they wouldn't get the result that the Fifth Circuit initially had come up with that broadened the scope of coverage. I think after Deepwater Horizon, there's been a lot less concern about tightening up the language. And I think that's not really a good thing, because the Deepwater Horizon case, it's a decision, it's a state, and the Texas Supreme Court will, of course, govern decisions under Texas law, but there are those other 49 states out there that could come up with different decisions. And even though the court in Deepwater Horizon ruled in a manner that was broadly in favor of incorporation of the contractual terms into the insurance policies, it still did so in a way that was mindful of the particular language. So I think insureds still need to be careful, and insurers as well need to be careful of the actual particular language in the policies, and not to simply rely blindly on the decision as being one that is favorable for limiting the additional insured coverage to the terms of the underlying contracts. Because in particular instances with certain type of language, you could still come to the opposite result and still open up the additional insured coverage, the policies, to much broader interpretation. The devil is always in the details. And in this area in particular, it's not really terribly difficult to craft language around the additional insured coverage that avoids all of these issues. You can have language that very specifically limits the scope of additional insured coverage to what's provided in the contracts that give rise to the additional insured coverage. It's not a complicated issue, and it's one where the insurers and the policyholders really are aligned. Their interests really are identical. They want to have the coverage limited to what's intended and what's supplied by the underlying contracts. So it's a situation where both sides really have an interest in working together to come up with language that accomplishes that.